fact, while hearing the SBI versus Rajesh Agarwal matter, the Supreme Court decided today that borrowers must be heard before banks declare their accounts to be fraudulent. Now, the Supreme Court noted that classification of accounts as fraud results in serious civil consequences for borrowers and amounts to blacklisting of borrowers. The court said borrowers must be heard under the Master Directions on Fraud. This is being seen as a huge setback for banks that use a central bank circular to classify frauds. The Supreme Court upheld a 2020 order by the Telangana High Court that was challenged by the centre. And as a result, under the Reserve Bank of India's Master Circular, banks must provide borrowers with an opportunity for hearing. The court emphasized reading the audi alteram partem principle, which means hearing the other side with the Master Circular. In fact, to talk to us more on this, I'm joined in by Anirban Datta, former banker, as well as Khushbu Jain, lawyer of the Supreme Court, on the broadcast. Good evening to the both of you. Thank you very much for joining us on Mirror Now. Khushbu, I'll come to you first. Of course, it's a significant development that's coming in. Just to draw things into perspective for our viewers, your first point of view about the same. Khushbu, if you could unmute yourself.
Apologies. So if I go on 2016 circular of RBI, that circular was binding on all the banks, where banks were to take action with regard to blocking of or considering these accounts as frauds and declare them as frauds. But this entire process was unilateral. The process was to be followed. The process of checking, getting the forensic audit been done, to and fro discussions with the borrowers. But this process was informal, not the formal one. And whenever they had to blacklist, if in the forensic audit something has been found that there is a money trail which goes in a wrong direction, that's where the blacklisting happened. But you would see that with time, there are a number of appeals which has been filed in the court that they were not given chance, they were not being heard, and the decision has been taken, without they being known to it. And there are some serious repercussions to this declaration of the account being fraud, and there are many consequences that come to it, which are very heavy for these borrowers to continue with. Hence, I think the Supreme Court came up with the part that 2016 circular stays absolutely perfect, but with an addition that any action which you take, a person against whom you're taking an action should not be unilaterally, it should not be arbitrary. A person who is party to it should be given at least an opportunity to be heard, one, and there should be a reasoned order that for what reason that is happening, so that there is no arbitrariness left into the order, and a person is having a right to say in that entire process. So that's the latest which has come by the Supreme Court as a clarification to the 2016 circular, saying that no more unilateral decision by the court, by the banks, but a process has to be followed where principles of natural justice have been followed. One, opportunity to be heard by the borrowers. One, second, the option where you have to give a detailed reasoned answer, order why it has been blacklisted or why it has been categorized as fraud, or what action has been taken on what basis.
Right, Khushbu. I'll take that point across to Anirban Datta as well. Mr. Datta, how do you view this? Do you see that as a setback as well at this point of time?
So I think this is a welcome move, and it has to be taken into a right spirit. Now the bankers should take more judiciously, take all those actions, and they should take the customer's consent as well. Customers should give proper explanations, and at the same time, RBI should come out with the process and the procedural, things, because the timeline should be given, because otherwise, people should take the chance out of it, and they will take much more longer time to, give all these explanations to the bank, so that, bank will take time to disclose these accounts as a fraudulent, fraud accounts. There are other dynamics to it as well, and as far as the fraudsters' activities are concerned, it may so happen that some of the fraudsters may take the chance and they may delay the process. But banks should take absolutely the right decision over the period of time, and knowing the justification of customers. And as far as the timeline is concerned, I'm sure that RBI should come out with a master circular with the proper timeline for justifications to be taken from the customers, and customers as a whole should also take the benefit out of this, judgment. But at the same time, overall, as far as banking transactions are concerned, we know that this is nothing but public money, and public money should be, secured at the cost of the, other things. Banks should give proper, due diligence while, signifying those transactions as fraudulent transactions.
Right. I'm going to take, as you make those significant points, Mr. Datta, let me take that across to Khushbu Jain. Khushbu, how do you see the fact that, the Supreme Court has also said that declaring an account as fraud leads to serious civil consequences?
See, when you talk about serious consequences, the consequences such as, there are civil actions, blacklisting of an account which has an effect on the accounts. Nobody can have a credit facility coming in place, so your entire business gets into standstill. So blacklisting mechanism which bars any credit facility to be taken by these, assessing any kind of credit facility by these borrowers, it can have an impact on you. And if say something has, without any reason, you cannot have somebody have such civil consequences or such heavy consequences being done. And if such heavy consequences come, then is where the chance that principles of natural justice is a basic principle which is being laid down, that if somebody takes an action against me, I should at least be given a right to be heard, and I should at least be known that on what reason. Give me a detailed reason so that there is no arbitrariness. One cannot act on whims and fancies. And I absolutely agree that banks do follow as per whatever the internal guidelines they must be having, right from asking questions to understanding, following the money trail, forensics audit to be done. But let that entire process be transparent. Let there be a show cause notice being given to me. Let me have a limited time period, 15 days, 10 days, 7 days, whatever time is being decided. Let me have a time period to reply to that show cause notice, that what is the reason of that money which has been found, or which has been found suspicious, or the reason for whatever the reason has been given. Once that is being done, and still if it is found, let after my reply, after my option of being heard, either in a verbal manner or in a written manner, is where you can pass a reasoned order. Once that reasoned order comes, is where the person has a chance to go and appeal option. You still have it, but without any reasoned order, it makes a very serious impact to your business, to your to your accounts, that you do not have any credit facility available from that period till the time you've been blacklisted, which has a heavy impact. So for that specific purpose is where that clarification comes, that let the process continue the way it is continuing as per the RBI circular of 2016, with an addition of as it is, this entire process was taken care by the bank, not that they do it just on the whims and fancies. There's a procedure which has been set aside. So why not make it more transparent and make it more involving the other party which has been affected so heavily, and make them party to it, and then follow the entire procedure.
Right, Khushbu, I want to thank you as well as Anirban Datta for joining me on Mirror Now and giving us your viewpoint about the same. But for the moment, we leave it at that. But coming up,